Hello, everyone. Welcome to another episode of the Lifetime Legacy Lawyer podcast. I am your co host, Thomas Vick, joined by my co host, Seth Wilson. Seth, how are you today?
Thomas, I am doing great. We've had a couple of uncharacteristically warm days here in January with some sunshine outside. So kind of felt like a snowbird a little bit because I got some vitamin D refreshment, I think, and excited to roll the calendar here into February and see what else is going to happen this year. January has been off to a good start, so just enjoying that and the clients we've been able to serve and help so far. How about you?
Yep, I had to go down to court yesterday and I took my coat off and just drove with my dress shirt on, and it was very nice. It was about 45 degrees in Franklin yesterday, and really enjoyed the sunshine and a respite from all the sub-zero weather that we've had in the wind chills under sub-zero temperatures recently. So that was good. This week we kind of wanted to shift our focus from wills to trust. I think we talked about some simple wills a couple weeks ago, and one of the interesting things about trusts is that they've kind of changed over the course of years. The trust that attorneys did in the early 1990s are a lot different than the trusts that are written today, the ones that you and I put together for clients. And a lot of that has to do with the changes in laws that have occurred over the last 30 plus years. And in my practice, I've seen some of those old trusts and seen how they don't work out well for a lot of folks. It becomes kind of cumbersome, and there are a lot of issues that arise because of some of these older trusts. And I thought today we might talk a little bit about how you know outdated trust can cause problems, and why people need to update them. So with that general introduction, I'll turn it over to you and kind of ask you what has been your experience with older trusts that are 30 years old or so.
Yeah, well, I think you're calling me old by calling me out on some of these. So
I am.
I remember when I first started practicing in this area of law, I kind of started off my career doing litigation and then had the opportunity to start getting into the estate planning and probate world, and really just found that was a great fit for me and my personality. And one of the first projects I worked on was researching what is known as an A B trust. And that type of trust is typically or was typically used as a way to reduce the potential federal estate tax a married couple would face to take advantage of basically the ability to fund trust A with a certain number of assets and take advantage of the decedent's unused exemption amounts at that time and hold those funds in trust, allowing the spouse access to some income off of that, but ultimately kind of holding those trusts in for the future beneficiaries. And then the other trust the spouse could utilize during his or her life. And then uh, the second passing would occur and we would have another tax analysis that would need to be done. And so, how I see this sometimes now is there are some of these existing trusts that are pre funded. And so we've already kind of divided up the assets. And so that in that scenario, most of the challenge that I think you're talking about here is probably already eliminated because it's already pre-divided, if you will, kind of half and half between the spousal assets. And so in those scenarios, again, every situation is unique. So you got to take a look at that with your attorney. But in those scenarios, sometimes it makes more sense logistically to leave those kind of set up that way, even with some of the changes that are here now. So that's kind of the historical context of that. Again, a pretty broad simplification of how that works. But what have you seen kind of in your practice then that has changed a little bit of that methodology?
Yeah, so I've come across a few of these AB trusts, and interestingly, the story that the client or the client's family tells me is that there was this financial company here in Indiana that did a bunch of seminars, and they went to a seminar, and they signed up for a trust, and they may have met with an attorney, they may not have met with an attorney. Unfortunately, a lot of them didn't meet with an attorney, and they signed up for this trust, and they thought that they were done forever. They didn't have to do anything else. So a married couple signs up for a joint trust, and then you know time passes, and unfortunately, one of these financial companies, at least one of them, got into some significant problems in Indiana because of uh, they were essentially practicing law without a license. And so a lot of people didn't really get the advice, in my opinion, that they needed when they were getting into these trusts. Um, and so, a lot of times I've seen where the the trust is in place, and the surviving spouse is now coming to my office after their spouse of so many years has passed away, and they're trying to figure out, what does the trust require that I do. And in some of these AB trusts, there has to be a division of assets, and some of the funds go into this B trust, which might be the A trust that you're talking about, and then the other one goes into the survivor's trust. And the surviving spouse has control over the survivor's trust, but there are some significant limitations on
Mm-hmm.
access to the principal that is in the family trust. And it's really there to, in some ways, it's helpful if you can kind of secure the the children's interest by saying, yes, spouse is going to have a right to the income interest from this family trust, but the children are going to ultimately be the beneficiaries, and so they're going to be the beneficiaries of the principal, and it's just going to be up to kind of the trustee's discretion as to how that principal is spent during the surviving spouse's lifetime. And that's not how a lot of these clients think about it. They think that the surviving spouse is going to have complete access to all of the funds, income and principal, and that can kind of rattle them quite a bit. And depending upon their financial situation, they're going to be dependent upon having all the funds available. And so, I had a case one time where all of these folks were there was a split interest, kind of a blended family situation, and so lots of consents and waivers had to be put together, and uh, I think we considered a non-judicial settlement agreement at some point, because we kind of had to put it back together and figure out you know who who gets what and what access do they get. um, and one of the problems with these AB trusts is they require that a corporate trustee will serve as trustee. They might name some individuals, but at some point, that financial company might have been the one named as the corporate trustee.